Hello everyone, today's vlog is on IR35. Quite a well-known piece of HMRC legislation, been around for about 20 years, has its genesis at the start of the millennium. The Y2K bug, remember that? When everyone thought the world was going to end, when all these computers couldn't cope with the date change for the year 2000, a lot of IT companies hired people to come and sort out the potential Y2K problem. And all these contractors that they hired, they insisted that they weren't on their books as employees. They wanted all these people to come and do work for them, but they didn't want to pay them employers' national insurance. So they said, look, engage as a limited company and we'll pay you consultancy invoices. And this took off around about 1999, 2000. Indeed, tens of thousands of individuals formed these limited companies to invoice in for their IT specialisms to the likes of FTSE 100 companies, BT and many others, when really they were only working for one customer, i.e. BT. So all these tens of thousands of one-man band companies only had one end customer, and to all intents and purposes, in HMRC's opinion, they would have been an employee. They would have been on the books of these FTSE giants had it not been for the fact they had themselves with this corporate wrapper around them called a personal services company. So what it meant was that the large customers were paying invoices for these IT guys who had their own limited company, and they were making use of the fact that you can pay yourself a certain way via a company, and overall your tax burden will be less. And that is still the case today as it was 20 years ago, that generally if you have a company and you're in charge of that company, you're in charge of your domain, and you can deliberately manipulate your earnings to whatever you want to be. Earnings being whatever you strip out in the form of salary and dividends, using earnings in a loose sense. Dividends aren't technically earnings, but you can choose how you pay yourself, how you remunerate yourselves when you have your own company. If you're an employee, you don't have any choice. It is salary, it is national insurance, and for any given level of income, you will always pay more tax as a rule as an employee. So if you have the choice to not be an employee and instead operate via a limited company, then that is what tens of thousands of people did. And lo and behold, they paid less tax and there was less tax take for the government. So the government cottoned onto this and they brought out this legislation, or rather Inland Revenue Interpretation number 35 as it was called, or IR35. And what it said was, if in reality you're not genuinely self-employed, if for the fact of this limited company that you have as your personal service company, put that to one side, you would be an employee of these other companies, then forget how you pay yourself via your company, dividends or whatever. We will assume that you fall inside this IR35 rule, and we will say to you, whatever you pay yourself from your company will be subject to pay as you earn. So broadly speaking, you'd pay the same amount in tax as you would have done had you been an employee. Now, what happened over the years, that primary HMRC's assertion was everyone, pretty much who has these companies, would have been an employee if it wasn't for them having their companies. But over the years, and so many tax tribunals and contractors gone to court, it actually turned out that HMRC won very few cases. Indeed, most of the contractors who went to court to challenge the fact that HMRC said they were caught by IR35, many of the contractors won their cases. So for a long, long time, the revenue didn't really get didn't get anywhere with IR35 because the taxpayers had a history of proving that they were genuinely self-employed. Now, when we say genuinely self-employed, it's all about the contract between the personal service company of the contractor and their end clients. comes down to several clauses, which we'll come on to in a moment. But essentially, the landscape didn't really change much for many years until about 4 years ago. HMRC said, right, we've had enough of IR35 and too many people not being caught within it. So what we will do, we'll change the rules, and for the public sector, so for the government, people who work for the government, people who work for the government via their own personal services company, HMRC said, okay, we will now put the onus not on the taxpayer to get it right, but on the end client or customer. So the likes of the BBC and the NHS, and the rule changed so that if the person working or invoicing, consulting into the NHS or the BBC were found to actually be not genuinely self-employed, but should have been on the books of those organisations, then those organisations would bear the tax, not the individual. So that was a real game changer. So rather than have the risk of employment taxes and penalties and fines put on them, the likes of the BBC and the NHS, they just said to thousands and thousands of people who were working for them through their own limited companies, they said, look, we don't want to continue with the risk of this going forward now that the risk is on us, so we'll put you on the books as employees rather than have that risk. Nothing actually changed in terms of the employment status, in terms of what does it mean to be self-employed and the various tests. That didn't change at all. But what happened was the risk of falling foul of the rules was shifted from the individual who had their own company to these huge public bodies. And they just said, right, we're just going to stop using limited companies and we'll put you on the books as an employee. Now, lo and behold, when that happened, the Treasury increased its tax take by several £100 million. So the government said, aha, right, now we're onto something. Now IR35, we're finally getting somewhere here. So they said, right, let's roll this out to the private sector. So this was supposed to kick in this year, but it's been delayed because of COVID. So from April 2021, any medium-sized companies and large companies in the private sector that engage with contractors, they will now have to risk assess to see are they genuinely self-employed or not. Because if they get it wrong, they will be subject to the fines and the penalties and paying the tax, like it's been the case for the public sector for a few years now. So a real game changer for the private sector. It doesn't apply to small companies who are the end customer, only for medium and large companies. But that is now going to happen from April 2021. So big changes coming up, but again, nothing changes in terms of status, employment status, the tests to see are you genuinely employed or self-employed. It's just the risk of getting it wrong is transferred from the individual and their company to the clients that they work for. Now, there is a lot of problems in this whole area. Is what does it mean to be genuinely self-employed? Specifically when you go on HMRC's website and they have a calculator there and you answer a load of questions, but unfortunately it's been proved in recent years to spurt out the wrong answer on umpteen occasions. So you can't take comfort from the answer that HMRC's own online employment status tool gives you. You need to speak to professional advisors who will do contract reviews to see whether or not you will be caught fall foul of IR35, so-called within IR35, if you have to pay the additional tax as pay as you earn, or outside IR35, if indeed you are deemed to be genuinely self-employed, albeit with a corporate wrapper around your business. So one of the interesting things about IR35 in recent years have been the celebrities who have been caught by this. Makes the tax world just that little bit more interesting. And we'll just talk briefly about some celebs in the last few years who have been at court with HMRC. Some of them have won and some of them have lost. And as I'm going to tell you, there's a fine line on some of these when you think, actually, it sounds to me like they're doing the same thing on the face of it. Why would some of them be deemed by the courts to be inside IR35 and some of them outside IR35? So recent successes for celebrities who were deemed not to fall foul of IR35 were Lorraine Kelly, who hosts her own show on ITV in the mornings, and Kay Adams, who is one of the lineup for Loose Women. So those two ladies were successful in their legal case that was brought against them by HMRC, but someone who wasn't successful and who lost out is Eamon Holmes. So let's have a little further look into Eamon Holmes' recent case, his appeal, which he lost in March of this year at the start of lockdown. And it basically hinged on a couple of factors in his contracts with ITV. Obligation, mutuality of obligation, MOO, and control. They're the two key areas in the contract that he had between ITV and his personal company. Now, what is this mutuality of obligation? It is an obligation between parties to provide and accept work. Okay? And control is basically how much control is put on from the engager to the engaged. So basically, if it is shown that there is a mutuality of obligation, you are obliged, or there's an obligation between parties to provide and accept work, that is an indicator of employment, not self-employment. Control as well, if there is deemed to be excessive control from one party to the other, that all points towards employment, not self-employment. And these were the two key ones where Eamon Holmes lost out on. So let's have a look. So with Eamon, he had a contract with ITV, and it was a contract for continual service in that contract. It actually said that he would receive full payments even if some of the shows were cancelled. You know, he hosts This Morning now and again. So he would receive full payment even if the show was cancelled. So that negates any financial risk. And obviously financial risk is one of the key things of being genuinely self-employed. So that clause in his contract points more towards employment than self-employment. So the mutuality of obligation point, he failed on that in the High Court. The other area was the area of control, and it was deemed that there were elements of control. It was overtly control exercised by ITV over Eamon Holmes that neither Lorraine Kelly or Kay Adams had. So remember, we're talking about three celebrities who both appear on ITV in the mornings between 9 a.m. and 1 p.m, but completely different when you analyse their contracts with ITV. So it was deemed that Eamon had a lot more control over him from ITV. So ITV decided who he would interview on This Morning. Various staff at ITV researched each interview and gave Eamon briefing notes beforehand. And there were restrictions. There were actually restrictions written into his contract, even into his personal life, including his leisure activities and the provisions relating to his state of health. Now that you would never see normally in someone who is genuinely self-employed. That all points towards an employment type of arrangement. So he failed on the control status as well. Now another feature of employment, self-employment, is the right of substitution. Normally, if you are an employee, you don't have a right of substitution. You can't just say, well, I don't feel like coming to work tomorrow, but I'll send someone else in my place. Whereas that can happen if you are self-employed. You'll just send someone else in your place. Now, Eamon accepted in the courts that ITV specifically wanted him to be the presenter and no one else. So on that point, he said, okay, I accept that fact, that the right of substitution wouldn't work in his case. However, when you compare it with Lorraine Kelly, she did have the clause in her contract where she could provide a substitute, and indeed she has on several occasions where she has organised someone to sit in for her on the show when she's away. She's organised it, she's chosen the person, and she's paid them as well. So that's a significant difference between Eamon and Lorraine Kelly, and one of the other things that point towards the fact that she won and she was deemed to be outside IR35 and he was deemed to be inside, even though on the face of it, well, they're both selling the same things. The fact that they are personalities and they're both selling a brand, i.e. themselves. So you've got to really be careful with what is in the contract. If you are a contractor engaging with the end customer, key clauses being this mutuality of obligation, level of control, right of substitution, and other issues as well. Some of the minor status tests that were in the contract between Eamon's company and ITV, that Eamon enjoyed several perks that you'd only expect ITV employees to have, such as the fact that they provided him with a car to take him to and from the studio each day from his home, and also to drive him to outside broadcasts, and pay to put him up in hotels. Now that wouldn't happen if he was genuinely self-employed. He would have to foot that expense himself. So again, pointed towards an employment relationship, and that is why he lost, and that is why he was deemed to be within IR35. We don't know exactly how much tax was at stake. That was not made public, but I can imagine it's quite a lot. Another celebrity who lost out a couple of years ago was Krista Ackroyd, the Look North presenter, and again she lost out on the level of the control and mutuality of obligation. So if you're a contractor watching this, I cannot emphasize enough how important it is to have that contract reviewed and learn from the mistakes of some of these celebrities to see exactly what you should and should not have in there, because it is crucial. But also remember that in terms of what is in there, that is not changing, that determination is not changing next year. Next year what is changing is the risk of getting it wrong, and the fact that because your engager, the person who you are working for, will have to stump up the tax if your employment status is wrong. If you fall foul of IR35, you're deemed to be in IR35, the end engager will have to pay the tax. And it could be that they just do what a lot of the public sector bodies do and refuse to use you as a contractor and say, unless you come on the books as an employee, which will mean paying more tax. But then, of course, if you're bargaining, you say, well, increase my daily rate, or whatever terms you can to compensate for the fact that you'll be paying more tax. So it's not the end of the world if you do have to go on the books as an employee. You just have to do some hard bargaining to make sure that you're no worse off. So yeah, please do let me know your comments on IR35. I look forward to hearing from you. And if you like this video and any of the others in my YouTube channel, then please do subscribe, and I will see you again soon.